Hello everyone, let me introduce myself first. My name is Jindo. I'm studying at Batam International University. I am a law student. I want to talk about business matter with foreign element in Private international law is adopted by civil countries. The meaning of private international law, conflict of law, or private international law, or international private law is branch of international law and interstate law that regulates all lawsuits involving a foreign law element where a difference in result will occur depending on which law are applied as the lex causa. The aspect of private international law. The first is the jurisdiction of forum. The second is the competing state of law. The third is the enforcement of foreign judgment. The status of foreign law. When the court is to apply of foreign law, it must be proved by foreign law expert. It cannot merely be pleaded as the court has no expertise in the law of foreign countries, nor in how they might be applied in foreign court. Such foreign law may be considered no more than evidence rather than law because of the issue of sovereignty. Preliminary matters in private international law. The first is characterization, the second is incidental question, the third is renvoi, and the fourth is choice of law, and the last one is Hague Conference. The meaning of characterization. Characterization is the procedure to resolve a lawsuit involving a foreign law element. Once the forum court has decided that it does have jurisdiction to hear the case, in then it then must character of classify the cause of action. The process is the court is required to analyze the pleading prepared by the parties and to assign its component element to the most appropriate judicial concept or category. The rules of any given system of law are arranged under different categories, addressing procedure, status, contract, tort, divorce, and nullity. For each category, there is one or more choice of law. For an incidental question, to arise, the forum court must have applied its characterization rule to determine that the main cause of action is governed by foreign law. As a precondition to the main cause of action, there is a subsidiary question which has its own choice of law, rule pointing to different lex causae. There will be a different result depending on which foreign law is applied. Incidental question. An incidental question is a legal issue that arises in connection with the major cause of action in lawsuit. The forum court will have already decided that it has jurisdiction to hear the case resolving any issue relating to forum shopping and will be working through the next two stages of the conflict process, namely characterization and choice of law. Choice of law is procedural stage in the litigation of case involving the conflict of law when it is necessary to recognize the difference between the law of different legal jurisdictions. The traditional approach looks to territorial factors, the domicile or nationality of the parties where the component comprising its cause of action occur where any relevant asset, whether movable or immovable, are located and choose the law or law that have the greatest connection to the cause of action. The parties themselves may plead the case either to avoid invoking a foreign law, or to agree the choice of law, assuming that the judge will not of his or her own motion go behind the pleading. The court in some states are predisposed to favor the lex fori wherever possible. Public policy or order public is the body of fundamental principles that underpin the operation of legal system in its states. This addresses the social, moral, and economic values that a society together, values that vary in different cultures and change over time. The example of public policy, the most fundamental policy in the operation of any legal system, is that ignorantia juris non executat. The Latin for ignorance of the law is no excuse. It will completely undermine the enforcement of any law the person potentially at fault was able to raise a successful defense that he or she had not been aware of the particular law. The only exception to the rule excuse those reduced capacity, whatever of infants or through mental illness. For example, see the principle of doli in capex, which raises an irrefutable presumption in the criminal law and infants incapable of committing a crime. Definitional elements. State. State is set of institutions that possess that authority to make that rules that govern the people in one or more societies, having internal and external sovereignty over indefinite territory. The state includes such institutions as the armed force, civil service, or state bureaucracy, courts, and police. State. In casual usage, the terms country, nation, and state are often used as if they were synonymous, but in more state usage they are distinguished. Country is the geographical area. Nation is designates a people, however, national and international both conventionally refer as well to matters pertaining to that are strictly state as in national capital international law. State refer to set of governing institutions with sovereignty over definite territory. Jurisdiction. Jurisdiction is from Latin. Juris meaning law and dicere meaning to speak. Is the practical authority granted to a formally constituted legal body or to political leader to deal with and make pronouncement on legal matters and by implication to administer justice within a definite area of responsibility, procedure or conflict. In all lawsuits involving conflict of law, question of procedure as opposite to substance are always determined by the lex fori, the law of the state in which the case is being litigated. Forum non-convenience is a legal doctrine used by the common law court to determine issue of jurisdiction, particularly with regard to foreign judgment and foreign court proceeding. The underlying principle, such as basing respect given to foreign courts and reciprocal respect or community, also apply in civil law system or at least alibi pendant. A concern often raised in application of the doctrine is forum shopping, or picking a court merely to gain an advantage the proceeding. Lex causae. Lex causae is from Latin. Causae law is the law or law chosen by the forum court from among the relevant legal system to arrive at its judgment of an international or interjurisdictional international case. The term refers to the usage of particular local law as the basis or cause for the ruling which would itself become part of referenced legal canon. Lex fori. The Latin term lex fori literally means the law of the forum, and distinguished from the lex causa, which is the law the forum actually applies to resolve the particular case. The approach of lex fori. When a lawsuit is intested and the court has accepted that it has jurisdiction, the parties would normally accept the local law to aptly reflecting a presumption of the territory that each state sovereign within its own border and the law of no other state or international body will apply extraterritorial or supernaturally. If foreign law did apply, the state would be less than sovereign within its own border. However, as social mobility has increased and internet recognized the relevance and importance of foreign laws to dispute resolution has arisen. Within the precise limits set by the lex fori, local courts may sometimes apply one or more foreign laws, as the lex causa if the local politics, public policy, and the dictates of justice require it. Forum shopping. Forum shopping is the informal name given to the practice adopted by some plaintiffs to get their legal case heard in the court of most likely to provide a favorable judgment or by some defendants who seek to have the case moved to a different court, either to dissuade forum shopping. Court may object to forum shopping for several reasons. Philosophically, the fair resolution of case should not hinge on technical difference from one jurisdiction to the next. On a more practical level, many judges feel that their courts are overburdened and fear that having the reputation of a forum favorable to certain types of plaintiffs will lead to an increase in the workload, thus delaying in dispensation of justice in other cases. Lis alibi pendens. The principle of lis alibi pendens, literally dispute elsewhere, pending, applies both in municipal public international law and private international law to address the problem of potentially contradictory judgment. If two courts were to hear the same dispute, it is possible that they might reach inconsistent decisions. The rule of lis alibi pendens. The first rule is res judicata, provides that once a case has been determined, it produces a judgment either inter partes or in rem depending on the subject matter of the dispute. Although there can be an appeal on the merits, neither party can be recommended proceeding on the same set of facts in another court. If this rule were not in place, litigation may never come to an end. The second rule, proceeding on the same fact cannot be commenced in second court if the action is already pending. Next, I will discuss the main topic in this explanation. The namely is business matter in private international law. Definition of business matter. A business contract that is entered into by foreign citizen or contains a foreign element. In business matter, there are several characterizations in private international law to solve business matter. Lex party. The term of lex party is Latin for the law is nationality in the conflict of law, which is the system of public law applied to any lawsuit, where there is a choice to be made between several possibly relevant law and different result will be achieved depending on which law is selected. The lex party is a civil law choice of law rule in some states. The law of habitual residence is used to the status and capacity of the parties to the case. Lex domicili. The lex domicili is the Latin term for law of the domicile. In the conflict of law, conflict is the branch of public law regulating all lawsuits involving a foreign law element where a difference in result will occur depending on which law are applied. The term lex situs refers to the law of the place in which property is situated for the purpose of the conflict of law. The example is property may subject to tax pursuant to the law of the place of the property or by virtue of the domicile of its owner. The lex situs is a choice of law rule applied to identify the lex causa for cases involving title to or the possession and use of property. In law, there are two types of property. Real property is land or any permanent feature on structure above or below the surface. Ownership of land is aspect of the system of real property or reality in common law system. Immovable in civil law system and conflict of law. All, all other property is considered personal property or personality in common law system, movable in civil law system and the conflict of law. And this property is either tangible or intangible, either or it is enforceable right like a patent or other form or intellectual property. Lex loci contractus. The lex loci contractus is the Latin term of law of the place, where the contract is made in the conflict of law. Conflict is the branch of public law regulating all lawsuits involving a foreign law element where a difference in result will occur depending on which law are applied. The lex loci solutionis. The lex loci solutionis is the Latin term of law of the place where relevant performance occurs in the conflict of law. Conflict is the branch of public law regulating all lawsuits involving a foreign law element where a difference in result will occur depending on which law are applied. The legal issue of the case is breach of contract. The incidental question, the first is does the American court have a jurisdiction? The second one is was the contract valid under the law? And the last one is Which law is going to try the case? The connecting factor. Lex loci contractus is American law. Lex situs is American law. The strongest link to the case is Washington D.C. Because of the contract was in Washington and also the object was in Washington D.C., concluded that Lex Fori is American law, Lex causa is American law. Argument of parties. James Forrest Lee, G.R. Trevor, M. Asabari, Lee and Miss Sain, P.C. Washington D.C. as the plaintiff of Winmar. First, Winmar sued Al Jazeera for violating the contract which is not paying off the debt. The second, as written on the contract, the payment will be complete until the end of December 2005, but Al Jazeera still does not pay off the debt even until the beginning of the month. The second, the Leslie Hook Wiesfelder, Lynn Marie Dever, Don Lohner, P. L.C., Washington, D.C. as the defendant of Al Jazeera. The first, Al Jazeera claimed the Winmar has a debt to Al Jazeera and has not yet paid it off. Al Jazeera claims that there are regulating lists of several documents submitted by Winmar, but when Winmar was asked, it did not want to show it because it claimed that there's no such thing in the contract. And the last one is, in the document made by Winmar, the amount of debt is stated which is not actual amount. Court of decision. The court concluded that Winmar was entitled to Hararwi Corporation versus Winery Corporation. Hararwi from State of Salak and Winery Corporation is from State of Kedondong. When Winery Corporation sends saffron, the saffron that is sent does not match what was contracted. In the contract in December, saffron must have arrived. Apparently, saffron arrived in Salak in January. And saffron comes with conditions not in accordance with existing contract. And after being investigated, it turned out the saffron that was sent was not the saffron that was inspected. So in the contract, it has been explained that the saffron is sent must be inspected first. So AG violate existing contract. Shipping does not match that estimate time specified. Saffron that is sent not inspected beforehand, so that health of the plant is not desired. Characterization. Hararwi Corporation. Lex Party Salak Law, Lex Domisili Salak Law, Winery Corporation, Lex Party Kedondong Law, lex domisili kedondong law, lex loci solutionis kedondong law. Incidental question. Does the court have a jurisdiction? Was the contract valid under the law? Which law is going to try the case? The strongest link to the case is kedondong law because the lex loci solutionis and lex loci contractus is kedondong law. Decision of the court based on law number 1 2019. Kedondong combines importing goods into the country will be subject to inspection completed by kedondong standard. Misara is from Tempe country and live in Tempe. She want to open a clothing store because the product is she sell are clothes, which means she needs clothing material to make product. So she bought material from Miss Kenya. She is from Tofu country and live in Egg. They both made deal with a contract in Egg country that Miss Sarah would pay first, then Miss Kenya would provide material. Miss Sarah paying material on September 22, 2019 from the Tempe, and Miss Kenya must provide material on 24 September 2019. But on September 24, 2019, Miss Kenya did not provide the material. Up to 3 days from Miss Kenya has not provided material. Because of Miss Kenya action, Miss Sarah sue Miss Kenya for breach of contract. Legal issue of this case is breach of contract. The incidental question. Does the Tempe court have a jurisdiction to try the case? Which law is going to try the case? Miss Sarah lex party Tempe law, lex domicili Tempe law, Miss Kenya lex party Tofu law, lex domicili Egg law, lex loci contractus is Egg law, lex loci actus is Tempe law, lex loci domicili comisi is Egg law, lex fori is Tempe court, and lex cause is Egg law. The strongest link to the case is Egg law. Conclusion: lex fori Tempe law, lex cause is Egg law. Public policy is in America except for foreign element. So this case could be tried in Tempe court. Forum shopping. Miss Sarah filed in lawsuit in Tempe court because she lives in Tempe. That means she doesn't need to spend a lot of money, and Miss Sarah knows that Tempe court accept the foreign element. The court of decision of court. The judge made a decision that Miss Sarah won the case and Miss Kenya should pay to the Miss Sarah as much $1 million. Sun State. Konoha Corporation is from State of Moon. Tangled want to make a contract with Konoha. Tangled want to import apple from Konoha. Tangled signed a contract with Konoha. When Konoha sent the apple that is sent does not match what was in contract. In the contract in mid-December, apple must have arrived. Apparently, apple arrived in Sun in January, and apple comes with the exciting contract. And after being investigated, it turned that the apple was was not the apple that was inspected the contract. It has been explained that the apple is sent must be inspected first. Because of Tangled contract negligence, he sued Konoha. The legal issue of this case is breach of contract. The characterization. Tangled Corporation lex party Sun Law lex domicili Sun Law. Konoha Corporation lex party Moon Law lex domicili Moon Law. Lex solutionis Moon Law lex loci contractus Moon Law. The incidental question, does the court have jurisdiction? Yes. Was the contract valid under the law? Yes. Which law to try the case? The strongest link to the case is Moon Law, because the lex loci solutionis and loci contractus is Moon Law. Decision of the court based on law number 1 2019. Konoha companies importing goods into the country will be subject to inspection completed by Moon Standard. Court number 1. Legal issue tort breach of contract because the import is ruled under the treaty and the applicant feels that commission is taking too much advantage over the rule. That the change of the treaty is having equivalent effect to quantitative restriction on import. Incidental question. Does the Court of North England have a jurisdiction? Was the contract valid under the law? Which law is going to try the case? The characterization. Bavarian Ledger, lex party English law, lex domicili English law. European Commission, lex party Luxembourg law, lex domicili Luxembourg law. Lex loci contractus Luxembourg law, lex loci actus Luxembourg law, lex loci solutionis Luxembourg law. English law does not accept the foreign element. Luxembourg law accepts the foreign element. Connecting factor. The strongest link to the case is English law. So the lex fori is English law because the lex loci solutionis is English law and lex causae is English law. The decision of the North England Court, Bavarian Ledger applied to the case to English court, but later the Court of North England denied the case because of forum non-convenience. English law does accept foreign element, and they were trying to forum shopping as well, so the court claimed that his case will be renvoyed to Luxembourg law. The court number 2.
legal issue or breach of contract because the import is ruled under the treaty and the applicant feel that commission is taking too much advantage over the rule, that the change of treaty is having an equivalent effect to quantitative restriction on import. The incidental question: does the Court of Luxembourg have a jurisdiction? Which law is going to try the case? The characterization: Bavarian Leger Lex Party English law, Lex Domicile English law, European Commission Lex Party Luxembourg law, Lex Domicile Luxembourg law, Lex Loci Contractus Luxembourg law, Lex Loci Actus Luxembourg law, Lex Loci Solutionis Luxembourg law. Public policy: English law does not accept foreign element. Luxembourg law accepts the foreign element. The decision of Luxembourg Court. After the Court of England Court renvoyed the case, the Court of Luxembourg accepted it to trial the case since Luxembourg accept foreign element, and the contract was under the law of England. So the law that going to try the case is English law. Lex Flore is Luxembourg law, Lex Causa is English law.